everyone. Thank you for joining us today for Constangy's webinar, Preparing for and Surviving an OFCCP Audit. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenter will leave some time to answer your questions. This program is approved for Sherman HRCI credit. We'll be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenter, Cara Crotty.
Great, thank you so much, Victoria. Hello, everyone. As Victoria said, I am Cara Crotty, and I am a partner in Constangy's Columbia, South Carolina office, and I'm also chair of the firm's Affirmative Action OFCCP Compliance Practice Group, and co-chair with my colleague, Poonam Rogers, of the Diversity, Equity, and Inclusion Practice Group. So I'm very excited to meet with all of you today and talk about your steps and some tips for preparing for compliance review with the Office of Federal Contract Compliance Programs. As Victoria mentioned, the presentation is being recorded, and I will probably try and take your questions as we go along, as long as time permits. If not, I'll might save some for the end, and then worst case scenario, I'll circle back with you afterwards if there are questions that I don't get to during the presentation. But we do have a lot to cover, and we're going to start off with a few basics before we start talking about audit prep itself. We want to make sure everybody on the call knows to whom these rules and regulations apply to, and you make sure you're in the right webinar. But we're going to be talking about who is a federal contractor that has to comply with the affirmative action laws and regulations, what agency enforces those regulations for contractors, and then we'll get into how are contractors selected for a compliance evaluation, what you have to submit during one, and then at the end, I'll give you some pointers or strategies for surviving an OFCCP compliance evaluation. So who is a federal contractor? There are three main laws, or three laws that the OFCCP enforces from an affirmative action standpoint. And one technically is not a law, it's an executive order. Executive Order 11246 requires federal contractors to take affirmative steps to recruit and attract and retain females and minorities to their workforce. Section 503 of the Rehabilitation Act requires federal contractors to recruit individuals with a disability. And then our Vietnam Era Veterans Readjustment Assistance Act, or VEVRA, requires contractors to take affirmative efforts to recruit protected veterans. And of course, all three of these do have non-discrimination components. So we cannot discriminate against females or minorities or anyone on the basis of race or gender. We can't discriminate against individuals with a disability and must make reasonable accommodations. And under VEVRA, of course, we can't discriminate against protected veterans. And I always like to do a little bit of level setting at the beginning around what affirmative action means, because it does mean different things in different contexts. So in our context here for federal contractors, affirmative action is about providing equal employment opportunity. So just like with all employers, we're required to provide equal employment opportunities to everyone, regardless of a protected characteristics. We are prohibited from discriminating against our applicants and employees. And then on the affirmative action piece of it, this is the requirement that federal contractors take good faith affirmative efforts to attract, recruit, and retain women, people of color, individuals with a disability, and protected veterans. So what is affirmative action not? It's not about quotas or reverse discrimination. And sometimes that's where there's confusion around the terminology or just the term affirmative action. Contractors are not required to hire or retain a certain number of individuals from any of those protected classes. And contractors are also not required to favor or provide preferences to individuals on those basis. Both Executive Order 11246 and Title VII specifically prohibit discrimination on the basis of race or gender. So quotas and reverse discrimination are unlawful. And I wanted to point out that the OFCCP regulations requiring affirmative action were not affected by the Supreme Court's decision in Students for Fair Admission, which held that affirmative action in college admissions was unlawful. That in the college admissions case, one, different laws were involved, but two, the universities at issue were specifically and acknowledged using race as a factor in selecting students for admission. Whereas here, under Executive Order and Title VII, like I mentioned, employers and contractors are prohibited expressly from doing that. So let's talk about coverage real quick, just so you know which of these laws you are covered by. Executive Order 11246 has two different levels of coverage. Very low coverage just for basically the non-discrimination aspect of it. If you have $10,000 worth of federal contracts or subcontracts, you're covered by that. And then you are required to develop written affirmative action plans once you have basically one contract worth $50,000 or more, and you have 50 or more employees. Once you're covered by the executive order, you would be required to develop written affirmative action plans. Under Section 503, the first level of coverage is $15,000 worth of contracts, and then you're required to develop written affirmative action plans for individuals with a disability once you have a contract worth $50,000 or more and 50 or more employees in the organization. And then for VEVRA, of course, we have to have a different level for coverage. Here, there's just one level, and once you have a contract worth $150,000 or more and 50 or more employees in the organization, you're required to develop written plans under VEVRA. Now, once you're covered by the regulations, that's when, and meet those thresholds, you're required to develop the written affirmative action plans on an annual basis. And generally, you will be required to develop a written affirmative action plan for each one of your establishments that has 50 or more employees. Now, unless you have a FAP agreement with the OFCCP, which is for functional affirmative action plans, you will be developing them for those physical locations that have 50 or more employees. Every employee in the organization must be included in a written affirmative action plan. So even if you have locations that don't do any federal work, they would still be required to have a written affirmative action plan if they're employed by the organization that has the federal contract. If you have remote workers, people that work from home, they should be included in the affirmative action plan where their manager is located. Employees who report to a manager who is in a different AAP, so their manager sits somewhere else, they have to be included both in the AAP where they're physically located, and then they drop out of that plan and they're also included in the AAP of their manager's plan. Same for employees in positions where the selection decision is being made at a higher level, and the decision is made by someone located in another plan. They're included in the plan where they're physically located and we'll walk through the analyses, but the workforce and job group analyses, and then they drop out and they're included in the AAP where that selection decision is made. Now, for those establishments that have less than 50 employees, you still have to do something with those employees. They have to be, like I said at the beginning, each employee has to be included in an affirmative action plan, but you're only required to develop the written plan for establishments that have 50 or more employees. So what do you do with those establishments that have less than 50 employees? The regulations give you three options. You can go ahead and do a small AAP for that location. It's just going to have fewer employees in it. The data is not going to be as meaningful or robust, but you're allowed to do that. Or you can include those employees in the AAP for the location that handles the personnel functions for those employees. Or you can include those employees in the AAP where their manager is. So you have those three options. And I'm going to circle back to this thought at the end when we're talking about strategies, because this is an area where you have a choice and can make a decision and have options. So we'll talk about that a little bit more. All right, what's the enforcement process? The Office of Federal Contract Compliance Programs is a sub-agency within the U.S. Department of Labor, and this is the agency that's responsible for ensuring that federal contractors are in compliance with these laws and regulations. So they will routinely conduct desk audits of federal contractors. This is where you get the scheduling letter, the lovely invitation from the OFCCP to submit your affirmative action plans for review. And then the OFCCP may also elect to come on site to interview employees and managers, collect additional documents and records. The OFCCP will also conduct corporate management compliance evaluations, CMCEs. These are what we used to call glass ceiling audits. They are of a company's corporate headquarters, and they're just a little bit more in depth than your routine compliance evaluation. They're looking specifically at middle and upper management to see if there are barriers to advancement for women and minorities and where those impediments may be. And just like the EEOC, the OFCCP does and can investigate specific complaints. So if you have if an employee or an applicant files a complaint with the OFCCP, they may very well investigate it. Sometimes they will refer it to the EEOC. But if it's a matter within their jurisdiction, they can retain it and do that investigation. If during an audit or a complaint investigation, the OFCCP finds that a contractor is not in compliance, then they would issue a notice of violation. And there are basically two types of violations. One are technical violations or record-keeping problems. This happens when contractors have not been engaging in their good faith recruitment efforts or haven't maintained all their records they're supposed to have. Those types of things. The OFCCP will cite the contractor, suggest that they resolve it through a conciliation agreement. And there's no monetary liability associated with those types of violations, but the conciliation agreement will generally require the contractor to provide progress reports to the OFCCP for a period of time. Could be 6 months, could be a couple of years, depending on the issue. So the agency can monitor the contractor for compliance going forward. And then the second type of violation would be for alleged discrimination. If during an audit, the OFCCP discovers statistical disparities, typically in hiring or compensation on the basis of race or gender that are not explained by the contractor, then they're going to allege that there's some discrimination in the process and again, invite you to conciliate and resolve those. But that type of allegation would result in the contractor making monetary payments to the alleged victims of discrimination. So if they were applicants, the contractor would be providing relief in the form of back wages to those individuals, same for compensation, making up compensation differences. And then there is the possibility of debarment. A contractor can be debarred from doing business with the federal government indefinitely or for a period of time. But that usually only results when a contractor refuses to comply. So as long as you're in good faith trying to comply and willing to resolve issues or even litigate whether or not you're actually not in compliance, you won't be debarred for those types of things. It's typically, again, when a contractor just says, this is not something that we are going to do, that the entity would be debarred. Just a handful of examples here of past OFCCP settlements, and some of these are many years old, but I think it's a good representative sample of some settlements, and I included a couple here to show that the OFCCP isn't just looking for discrimination against women and people of color. If the numbers take them to conclude that men or non-minorities are being discriminated against, then they will pursue that just as well. So just like with Title VII, the executive order says that females are, or says that individuals are protected on the basis of race and gender. So that includes men and non-minorities. And you can also see from this small sample of monetary settlements that the amounts can certainly be rather significant. Some of these are on the smaller side. They can definitely get into 7 figures and more. All right, how are contractors selected for audit? Before we jump into that, I see if I have a question here. Which is a you know, it's I think the question we're all asking, do you expect President Trump to revoke Executive Order 11246? I do wish I had a crystal ball and could answer that. I don't know. Certainly there are conservative factions on the transition team that I think are suggesting that. But whether or not that will happen, I don't know. That's definitely a wait and see. But the president does have the authority to issue and rescind executive orders. So we'll have to take a wait and see approach. I think it is a possibility. However, I think it's just as possible that that President Trump can use the OFCCP to focus on inappropriate not DEI efforts or just policies in general that have an adverse impact on the basis of race or gender, again, regardless of whether it's for females or minorities, but also men and non-minorities. So we could potentially see that focus from the OFCCP. So the OFCCP schedules contractors, or let me back up. The OFCCP usually develops a list of contractors to audit about twice a year. It varies a little bit, but generally twice a year. They come up with a methodology for determining who's going to be audited in that cycle. And it changes. At least they tweak it somewhat. It does seem like the same contractors and the same locations do unfortunately have to suffer through repeat audits. But it is changing periodically. Sometimes they will focus on certain industries. For example, after the pandemic, they focused on the industries that tended to show growth during the pandemic as opposed to retraction in the numbers of employees. We've also, in one scheduling cycle, seen them focus on contractors that did not certify compliance in the OFCCP's contractor portal. But they like to, or the OFCCP always reiterates that it's not a random process for scheduling contractors, but it is neutral. So they are not targeting any specific contractor, but they develop their criteria for whom to audit, and then apply that to kind of the universe of all contractors. And we can actually see the methodology that the OFCCP is using for the past few years. They've actually published it with every scheduling cycle that comes out. So you can see over time what criteria that they have applied to each scheduling list. They're at at the link here. So as you're probably aware, the latest CSAL corporate scheduling announcement list just came out less than a month ago. It's called the 2025 list, and that's just because their fiscal year starts on October 1. So we're already in 2025 for them. But it was issued in November. It includes 2,000 establishments. And let's see, of those 2,000, most of them are establishment-based reviews. There are 60 CMCEs, 60 lucky companies that get to go through a corporate management compliance evaluation. 48 functional AAPs were noticed, and then 12 university reviews. And the OFCCP in its scheduling methodology for this list said that it's focusing on establishments that have 400 or more employees. So it's kind of going back to, we want to look at those larger contractors. The OFCCP also stated in its methodology that it did not include more than 10 establishments of any one parent company. So it capped it at 10, not much of a gift if you have 10, but I guess there's always the possibility it could have been worse, because 10 in any given cycle is obviously a lot. The other thing to keep in mind, if you're on the latest CSAL, if you're also on a prior CSAL, doesn't mean you're coming off that list. They will continue to audit all of the contractors on their prior lists, as well as this new corporate scheduling announcement list. And I will also say that letters from the CSAL have started going out. So if you're on the list, definitely be aware. The scheduling letter and itemized listing from OFCCP is typically directed to the CEO, the establishment's managing official, or the EEO1 certifying official. And typically what we see is that the investigator will reach out to the person on the EEO1 reports who's identified there. They have the email address and they figure that's a good place for them to start. And they'll solicit the correct contact information to where to send the letter, and definitely lets you know that it's probably imminent. The issuance of the letter is imminent. But the letter itself will identify the establishment that's under review and for which you have to submit your AAPs, tells you which OFCCP office is conducting the compliance review, as well as the investigator that will be involved. Reminds contractors that they have to preserve relevant records. So if you have any automatic purges or deletions, you need to suspend that as it relates to records that are required to be retained for OFCCP compliance. And then the OFCCP will allow for extensions of the 30 days to respond in only limited circumstances. Currently, under the agency's existing policies, contractors will only be granted an extension for extended medical absences of key personnel. None of those terms are defined, mind you. So I don't know what extended means or who is key. Disaster affecting records retrieval, unexpected military service, absence of key personnel, or unexpected departure of your key affirmative action officials. So the fact that you might be one of those contractors with 10 establishments being audited, that's not a reason for an extension. So the agency expects that you will always be audit ready. Whether or not that's a reasonable expectation is certainly debatable. Also, if you have a campus-like setting, and this applies mostly to colleges and universities, but it could also apply to other types of contractors that have cover a wide geographic area that might have different AAPs. The OFCCP scheduling letter requires that you submit the information for all of the AAPs that you have in that same city for the compliance evaluation. All right, so what must be submitted during an audit? I'm going to give you highlights of the itemized listing. And when you get the presentation tomorrow or next week from Victoria, I have at the end the actual language for each item in the itemized listing for your reference. But for purposes of the slides and the presentation, I kind of streamlined the verbiage to hit the high points, but you'll get the presentation, you'll have the full language. And the number here on these slides corresponds to the number of the item in the itemized listing. So hopefully that when you kind of look at everything all together, that will help make sense. But the first item is your organizational profile profile for your workforce in your females and minorities AAP. This is either the organizational display or the workforce analysis. You have the option of presenting your employees in either format. I think most contractors typically use or provide the workforce analysis. It seems a little bit easier to prepare with the data that's available. But this outlines the information that you have to provide for your employees as of your planned date. I noted here under the workforce analysis that employers are required to provide or to identify lines of progression in the workforce. That does seem to be a renewed focus of OFCCP. It's always been in the regulations as something that must be noted, but I've never previously heard of them asking about that. So it might be something you can address in the narrative. You can't do it in your workforce analysis reports directly. And of course, if you are rolling employees up from a smaller establishment, or you've got employees that are coming in because they report into that plan, or coming out because they report somewhere else, you should make those annotations in your organizational profile. Numbers 2 and 3 in the itemized listing pertain to the job group analysis. So this is where we break our workforce down by our EEO1 categories into smaller groupings. So we'll be grouping employees based on similarity of their job content, their wage rates, and opportunities. And the job group structure is how all the rest of the analyses in our AAP for females and minorities will be prepared. We have to show the percentage of minorities and females in each job group in our job group analysis. And again, we have those annotations for people that are coming in or going out of our AAP. Number 4 is the availability determination. This is where we are providing an estimated availability for females and minorities for each job group based on the external availability, that percentage of females and minorities with the skills in our recruitment area. Typically, we're going to assign our census codes and look at where we generally recruit from or could recruit from to fill positions in each job group. And then we also look at our internal availability, where are females and minorities coming from in our workforce, what other jobs are going to feed into the job group we're analyzing. So we determine the estimated availability of females and minorities with those factors, based on those factors. And then, of course, we have to compare our current employee representation to the estimated availability of females and minorities, where the percentage of female or minority representation is less than what we would reasonably expect, then the contractor must create a placement goal. And that's what the regulations say. It's that vague. Representation is less than what you would reasonably expect. So it's not expected to be equal. No, it's not, doesn't have to be ideal or perfect, but you would like generally your representation to be within a certain range of what the estimated availability is. And generally, I think most contractors will apply a statistical analysis to see if the difference between the estimated availability and representation is reasonable. And then, of course, if we determine that we are out of line with what's expected and we need to set a placement goal, that placement goal is going to be the same as what we estimated our availability to be. Number 7 on the itemized list, action-oriented programs for our females and minorities AAP. The OFCCP wants or requires contractors to provide documentation demonstrating the development and execution of action-oriented programs that are designed to correct any problems identified from an in-depth analysis of the total employment process. So contractors must evaluate at least their organizational profile and their job groups for problems with female or minority representation or distribution amongst the workforce. So you're looking for underrepresentation and potentially areas of overrepresentation as well. Do we have, predominant number of women in our entry level, lower paying jobs? Do we have potentially a distribution issue there? We want to, or we're required to evaluate personnel activity to determine if selection disparities exist. So this is our adverse impact ratio analyses, where we're looking at the selection rates for across gender and racial lines to see if there are statistically significant differences, and if so, can we explain them? So contractors don't have to submit those adverse impact analyses to the OFCCP. It's not part of, you're not going to hear me reference it as one of these items in the scheduling letter or itemized listing, but clearly the OFCCP expects you to be doing them. It is part of the regulation. So I think it's a strategy decision for each contractor on whether or not to include it. Certainly the results may bear on that. But I think particularly if you've got good, clean results, there are definitely reasons why you would want to go ahead and show those to the OFCCP. One is just to document that you are doing the what the regulations require you to do. We're also required to evaluate our selection, recruitment, referral, and other personnel procedures to determine whether or not we have disparities in employment or advancement for women or minorities. And then there's a catch-all for any other areas that might impact the success of the AAP. And here, and I will note this in other areas as well. I think in the past, contractors have done, maybe let's call it a cursory explanation in this area. And the OFCCP has not questioned or quibbled with it. But I have been noticing pushback from the OFCCP if they're getting a bare bones or something that looks kind of boilerplate without really much thought or detail behind it. So I think this is an area for contractors to really review in more detail before submitting your documents to the OFCCP during an audit. Now we're getting into the sections for the individuals with a disability and protected veterans, AAPs. And so you'll see more than one number here. And that's because generally what they're asking for, since the regulations are virtually identical, they're asking for basically the same information for individuals with a disability under Section 503 and protected veterans under VEVRA. So I've just included that. I've combined them into one slide for easier reference. But for 8 and 12, they're looking for contractors' outreach efforts. What are you doing to try to recruit individuals with a disability and protected veterans to your workforce? And they want to see the documentation of those efforts. And not only that, but they are now requiring you to provide your assessment of the effectiveness of those efforts. So it's not good enough to just say, yep, here's where we list all our jobs. We're in compliance. We always, we have great referral sources. They require you to be doing an evaluation of whether or not those efforts are effective. So at a minimum, you have to provide to the OFCCP documentation of all of your recruitment activities towards individuals with a disability and protected veterans. You have to explain the criteria that you use to evaluate the effectiveness of each one of those efforts. You have to determine whether or not you found each effort to be effective. And I think this is still a question mark that's out there. A lot of contractors will rely on a vendor to do a good portion of their recruitment. Because they're able to do it efficiently and they know they're covering all their bases. They're hitting the state unemployment agencies. They're hitting diverse recruitment sources. So it's a relatively quick and easy way to satisfy the cumbersome, very burdensome recruitment obligation that federal contractors have. I think the issue is that one effort, or is it multiple efforts when you're hitting all these multiple sources? So let's just say I think that's still up in the air with the OFCCP, but based on my experience with the agency, if you go back and say, well, this is our one recruitment source, our one agency, and this is what we found, I think they're likely to push back and say that's insufficient. Regardless, you also have to tell them what more you're going to do on the recruitment front if you come to the conclusion that your efforts, the totality of your efforts, were not effective. They want to know what else you're going to do, because it's not sufficient to just keep doing the same thing over and over if you're not showing results. Numbers 9 and 13, this is the audit and reporting system for individuals with a disability and our protected veterans. And again, we got to focus on this requirement, I think, in much more detail than we have as a group, as contractors have in the past. They want information and documentation showing that the contractor has measured the effectiveness of their AAPs, indicated if they found there was any need for remedial action, the degree to which their objectives, the objectives of the AAP, were attained, measuring compliance with the specific objectives, and then documenting any actions taken to comply with the audit and reporting system requirements. They don't give you a lot of, the OFCCP doesn't go into a lot of detail regarding what they expect to see for each one of these items. So I think contractors do have some leeway to be creative, but obviously the regulations will be your guidance on what you need to look at for compliance purposes. So again, an important point of your AAPs and submission for compliance evaluation. Items 10 and 14 are the data collection analyses that we have to do for both individuals with a disability and protected veterans. We are required to report on, during our AAP year, the number of job openings that we had, the number of jobs that were filled, how many applicants we had, how many people were hired, how many applicants that were an individual with a disability, how many applicants that were protected veterans, and then how many of those individuals with a protected veteran, individuals with a disability and protected veterans were hired. Sorry about that. So they call this, for some reason, the data collection analysis. There's no analysis really going on. You're just reporting numbers. But you will use this information. I think it's helpful when you are evaluating the effectiveness of your recruitment efforts. It can tell you, well, how many, what percentage of our applicants were individuals with a disability or were veterans? What percentage of our hires out of our applicant pool were disabled or veterans? So it is useful information for you to use when you're performing that assessment. And at this point, this is where we start getting into and if you are 6 months or more into your AAP year, when you receive the scheduling letter, you get to provide even more information. So at this point, the data collection analysis is the first place in the itemized listing where the OFCCP says you've got to provide not just the 12 months of data for your AAP year, but at least the 6 months of data for your current AAP year. So we're talking at least 18 months total of data and information to be submitted. Item number 11 applies just to individuals with a disability, obviously, because it's your utilization of individuals with a disability as of your planned date. So you're comparing your employees in your workforce by each job group to determine whether or not it meets the 7% utilization goal for individuals with a disability. And then if that goal has not been met in any job group, you are required to provide a description of the steps taken to determine where or whether and where impediments to equal employment opportunity exist, including the assessment of your personnel processes, the effectiveness of your outreach efforts, the results of your affirmative action audit, any other areas that might affect the success of your AAP, and again, the description of your action-oriented programs. Here again, if you are 6 months or more into your affirmative action plan year, when you receive the scheduling letter, you have to do basically run a mid-year report on your employees, and run the 7% utilization goal on that mid-year snapshot of your workforce. And then number 15 is the corresponding portion for veterans, where we are looking at our annual hiring benchmark. You are required to provide the documentation that you adopted the benchmark for protected veterans in your AAP. Depending on your plan date, the goal might be a little bit different. The goal is based on the percentage of veterans in the national civilian labor force, which changes every year around the end of March. So your plan date will determine what the annual hiring benchmark is. This year, since March 31st of this year, it's been 5.2%, unless you elect to adopt and create your own unique protected veteran hiring benchmark. And technically, you don't have to even provide the measurement towards that benchmark unless you are more than 6 months into your plan year, and then you are required to provide that information to see if the percentage of hires is protected veteran hires is 5.2% or more. Now we're starting to get into the support data in the itemized listing. So this slide talks about numbers 16 through 18. 16 is the EEO1 reports. You have to submit either your EEO1 reports, or if you're an educational institution, your IPEDs for the last 3 years for this establishment that's being audited. If you have collective bargaining agreements, you are required to submit that, as well as policies that implement or explain your CBA. And then 18 is the big one. You are required to submit your applicants and hires, promotions, terminations, as well as your prior year workforce by either job title or job group. Of course, providing information on race and gender for each one of those during the 12 months prior to your plan year. So your applicants and hires is certainly the area that's most likely to result in monetary liability. So we need to make sure that we are reviewing that data very carefully for accuracy and completeness. We want to make sure we're taking advantage of the internet applicant definition and not counting the people that don't meet the definition of an applicant, that aren't qualified, that weren't considered, or that withdrew prior to receiving an offer, because that will likely reduce your odds of seeing adverse impact in the hiring process. We are also required to provide any policies and practices relating to promotions. So how are promotions awarded? Is there a bidding process? How do you go about inviting internal candidates for job openings? And then we may provide, it's not required, but you may provide data regarding whether your promotions or certain promotions are competitive or non-competitive. So some employers will have that in their data, and you can tell whether or not this was an opening that was available to others, or if it was just a step or ladder increase that really wasn't competitive and others would not have been considered for. And of course, if we are 6 months or more into our plan year, when we get the letter, we have to provide all of that employment activity data for the first 6 months of our new year. A lot of data and information. Number 19, another big one, your compensation data. If you haven't been audited in a couple years, take note, because this has been significantly expanded. Not only do you have to provide the snapshot of your employees as of your plan date, but you also have to provide it of your prior year plan date. So 2 snapshots of your workforce, and you have to provide the detailed employee level compensation information for all of the employees on both of those dates. That obviously includes their race and gender and job title and pay information. You're also required to list out the separate components of compensation for each one of those snapshots. So bonuses, incentives, overtime, that type of thing has to be separated out and provided individually for each employee. And you're also invited to provide information around other factors that determine or influence compensation, such as education, experience, time and job, location, geographic differentials, performance ratings, all those types of things that will often have a big effect on someone's compensation. If you can include it in the data, if it's readily available, then it's probably a good idea to do so, because it will explain compensation differences. And then the last piece on compensation are your compensation policies. You want to make sure that you are providing all of your policies and practices around comp, how initial comp is determined, pay adjustments, salary history, and setting pay, those types of things. That's all information that needs to be submitted to the OFCCP so that they can understand your compensation. For prior year goals, you have to show if you established any goals for females and minorities in your prior year. And then if goals were established, you have to show the number of placements into those jobs during the year to see whether or not the placement goal was achieved. If you didn't achieve a goal, you're supposed to describe your specific good faith efforts made to do so. What did you do to try to remove any barriers and expand your equal employment opportunity? Of course, this is another area where if you are 6 months or more into your year when you get the audit letter, you're measuring your progress towards your current year goals and submitting that to the OFCCP. Item number 21 is information about your recruitment and selection processes. You are required to provide the documentation about what your practices are to recruit, screen, and hire people. And the request says that it includes the use of AI and algorithms and other automated systems, but it's not limited to that. So the agency has made it clear. They've received a lot of not applicable responses to this. If a company is not using AI, and they say, no, we're not just talking about AI, we're talking about just in general what your policies and practices are. So, so you are required to provide that as well, even if you are not using some automated or artificial intelligence. 22, the evaluation of your compensation system. This is addressing the portion of the regulations that requires contractors to do an annual evaluation of your compensation system. So you are required to explain to the OFCCP what you've done to evaluate your compensation at this establishment. When did you do it? How many people were included, who was excluded, what types of compensation did you evaluate, what method did you use, and so forth. So this is basically in lieu of you showing us your compensation analysis, you have to provide enough information so that we can confirm it was performed. And then 23 through 26, more miscellaneous support data. You have to provide reasonable accommodation policies, as well as the requests that were made by employees at this establishment and how they came out. Were they granted? Were they denied? If they were denied, why? Your EEO, anti-harassment policies, your complaint procedures. And then 25, your most recent assessment of your personnel processes. What assessment did you do? Did you identify any problems? What actions did you take? And then finally, the most recent assessment of the physical and mental qualification standards. What's your schedule for doing that? Did you take any actions as a result of the assessment? For the accommodations and your EEO policies, you have to provide up-to-date information if you're more than 12 months into your plan year. Now, The OFCCP thinks that it only takes contractors 37.5 hours to do all of that for one establishment. That's how they estimate the burden for evaluating instructions, searching your existing data sources, gathering and maintaining the data needed, and completing it and putting it all together. I think that defies logic, but you can count this hour towards your 37.5 because I think that is included in understanding and evaluating the instructions. But that really is laughable. It takes contractors, really regardless of size, a lot longer than that to put all this information together. But that's what they say. All right. My top 10 strategies for preparing and surviving an OFCCP audit. First, review the corporate scheduling announcement list when it gets released. Again, like I mentioned, a couple times a year, the OFCCP will send out an announcement. I'm sure you get inundated with blogs from vendors and law firms. We'll keep you up to date. You want to know when you're on there, but take advantage of that. You might not get a lot of advance notice, but any advance notice is good. That 30-day window is laughable. So you really need to jump on it as soon as you know you're going to be audited. 2, assess your AAP establishment structure. So we talked about the people you have to include because they're reporting into it, or exclude because they're reporting somewhere else. And then the roll-ups. Sometimes you might have an establishment where you are rolling up people from a smaller location that has less than 50 employees. You don't have to do that. So you might want to evaluate whether or not for the plan that's going to be audited for the OFCCP, does it make sense for this cycle? Maybe we just do a separate plan for that smaller location, because if you have fewer numbers, it tends to decrease the likelihood that you're going to have adverse impact. So something to evaluate there. You want to make sure you review your existing affirmative action plans and develop your priority list. What gaps do we have? Do we have everything we need? Has our plan expired and we haven't redeveloped it? You always want to make sure you have a plan in place as quickly as possible after it expires. So review what you have, update what you need to. 4, be mindful of your AAP date with respect to the timing of the potential audit. And honestly, there's not a whole lot you can do here. But because you never know when you're going to receive the scheduling letter. So you can be as prepared as possible, have everything ready to go, and then your plan expires and you got to develop a whole new plan. That can happen, definitely. And for example, if you were to receive a scheduling letter today if you have an AAP date in January, you have the option of submitting the AAP that's going to expire, plus all that year-to-date information, or you can submit your new AAP, but you are going to have a limited amount of time potentially to develop that new AAP and get everything in place. So that can definitely put you between a rock and a hard place. I would say, generally you're going to be better off if you only have to submit a current year AAP as opposed to the additional year-to-date information, but it may not always be feasible just depending on the timing. 5, research areas of adverse impact, especially in hiring. Like I mentioned, adverse impact is hiring is the most likely factor in a compliance evaluation resulting in monetary liability. So if we have any areas of adverse impact in our applicant and hire data, do a deep dive. Are we counting the right people? Are we grouping them appropriately? There are all kinds of strategic ways you can look at the data to make sure your analysis is accurate. Like I said, you don't have to submit that adverse impact analysis, but you should be doing it because the agency is going to certainly run their own analysis of the numbers. So be prepared. And, again, we want to do what you can to submit an AAP that does not have adverse impact in the applicants and hires. Analyze your compensation practices, preferably under the attorney-client privilege, so it's not a discoverable document or analysis. And often, a lot of organizations will do pay equity analyses for their entire organization, and that's fine. That's fine for compliance purposes. But that's not the compensation that you're submitting to the OFCCP for the compliance evaluation. So I do recommend that you look at the pay, analyze the pay for the employees that are being submitted for this establishment, because that's what the OFCCP is going to be looking at. So you want to make sure if there are pay disparities in this grouping of or set of employees, that we have explanations for it. You want to gather your non-data elements in the itemized listing, the policies and procedures that we talked about, your EEO-1 reports, all those things that you can gather and are not going to change over time, regardless of when the scheduling letter gets received. I mean, unless the policy gets updated, but they're basically going to be static. And potentially, if you have more than one audit, it will carry over from establishment to establishment if you have consistent policies at multiple locations. But you can get those done, have them out of the way so that you're not worrying about those things during your 30-day window to submit your affirmative action plan. Number 8, evaluate your recruitment efforts. Like I mentioned, the OFCCP is really doing a much thorough assessment of contractors' efforts in this area. What are you looking at? How are you evaluating your recruitment efforts? And they really want a detailed review of what was your return? Where were your applicants coming from? And what were your recruitment sources? Did you get a good return on your investment with those recruitment sources, or do we need to look elsewhere? So it probably sounds easier than it is, but a lot of it is data driven based on the information that you get from your applicants, which might not always be crystal clear. So look at what information you have available about those recruitment efforts and see how you can evaluate the effectiveness of those. 9, train decision makers on affirmative action commitments. If the OFCCP decides to come on site, they're going to want to talk with managers and supervisors, probably individuals that are involved in making decisions around compensation or hiring. And one of the things that they will ask them if they are familiar with the company's EEO and affirmative action policies and practices. So we want to make sure that they can speak to that and say, oh, yes, we received training on that. Hopefully it's part of your annual, EEO update training or information along those lines. But we want to make sure that they will be comfortable and knowledgeable about the company's policies. And then 10, finally, review information on your career page for compliance. The OFCCP will go to your website and they're going to look and see where you have jobs posted. What are you telling your applicants? So do you have links to your posters that you're required to have available for applicants? The Know Your Rights poster, paid transparency, all of those posters that are required to be available. Do you have them accessible? Do you tell applicants with a disability how they can request a reasonable accommodation in the application process if they need it? And do you include your tagline? Do you have information showing that you're an equal opportunity employer, including for disabled and vets, on your job postings? And my bonus tip, engage legal counsel. I know it sounds self-serving, but compliance evaluations are very complex, as you can see as we went through this. There are lots of ways to get tripped up. You need legal advice and counsel during this process that can potentially result in monetary liability for the organization. So any benefit, advantage that you can get from having counsel in this area is definitely worthwhile. I'm going to open it up for questions, and I also here are the codes for your credits. And don't freak out, I'm going to come back to this, but I just wanted to show you in the slides that you're getting from Victoria. Here's where at the end of the presentation, I have the itemized listing and the full verbiage of each one. And here's the link where you can find it on the OFCCP's website. But here you can see the whole item is listed out completely for you. So I'll go back to that now. All right, I've got a minute or so left. I don't see any other questions, but you are welcome to reach out to me at any time if you have any questions. Oh, here, I've got a question. Is it true that in 2025, the OFCCP is reinstating the monthly employment utilization report? That is true. That's for construction contractors only, however. So that's starting, I believe, in April of next year, presuming that the Trump administration doesn't decide to change course. Currently, that will be a new requirement. And there's a link on the OFCCP's website to FAQs about that. So you can kind of get a, for construction contractors, you can take a look at that to see what your requirements are. But yeah, you're going to have to go back to monthly reporting on hours worked, specifically women and minorities on your construction projects. So with no further ado, like we mentioned, Victoria will be sending the slides out as well as a link to the recording. So if you just didn't get enough in this 1 hour or you want to forward it to your colleagues or friends, please feel free to do so. Thank you so much for joining me today. I hope this was helpful.